everyone, to a very special episode of Circle City Conversations today. Today we are having a fireside chat with my dear friend Tim Devereux, who I'll introduce here in just a minute. I want to thank our sponsor, Limontes, an Indiana law firm with many years of experience helping injured Hoosiers and their families. And so, like I said, today we are here at a very special location at the basement of my house here in my own private bourbon bar with my dear friend, an excellent lawyer, a father, a husband, and someone who, like me, helps people seek justice. My dear friend that I've known for a long time, Tim Devereux.
Glad to be here.
Tim, thank you so much for being here. I appreciate it.
I've been looking forward to this.
So before we start with the interview and talk a little bit about Tim and his very long and storied career and still many years to come too. So before we do, you brought me a special gift. You did, didn't you?
I did bring one.
Yes, as one fellow bourbon head to another. Tell me a little bit about this.
This is a New Riff Maltster, and New Riff is based out of Newport, Kentucky, so it's probably the closest Kentucky distillery to Indianapolis.
Wow.
It's fun. I like rye, and all of their bourbons are on the high rye side, so they've been playing around with different malts to try and broaden the appeal. Like they want to attract Scotch drinkers.
Okay.
So they're using malts in some of their whiskeys. Huh. So this one's got a special, I'm trying to remember the exact name of it. It's called a crystal malt, and then there's a malted rye in here as well.
All right, well, let's pour one and have a drink while we chat.
Sounds good.
All right.
I have never had this before.
You haven't? Well, neither have I, so that makes...
This was one of their seasonal releases.
That makes two of us, my friend. Salud.
Cheers.
Oh my God, that's so good.
That is not bad.
That is so smooth. They really do a fantastic job at New Riff. I had a buddy of mine put me onto this. I was telling you, my buddy that has bourbon, and it's just so delicious. Really.
It's probably my favorite distillery at the moment.
Yeah, I mean, a lot of times people will drink bourbon and they'll drink it straight up like this, or on the rocks or neat, and it's such a warm liquor, that not a lot of people enjoy by itself, but this bourbon like this, I mean, you have to drink it by itself.
Oh yeah.
Yeah, you cannot dilute it with anything. So Tim, we usually start with a lot of our guests, especially lawyers like you, just kind of talking a little bit about yourself, where are you from?
Okay.
Tell me a little bit about, growing up in your childhood.
All right. Well, I actually grew up just over the state line in Illinois.
Okay.
I was born in Kankakee and spent most of my childhood there. My family then bought a business in Decatur, Illinois. Mm-hmm. So that's where I spent my high school and college years. And after I graduated from Millikan University, which is there in Decatur, I went to law school at the University of Denver. And okay. I was out in Denver for about 10 years. And then I started practicing out there. And my first law clerk job was with a plaintiff's firm. And I moved on to a bigger plaintiff's firm. And when I graduated, that firm made me a job offer. So I unintentionally fell into plaintiff's work. I found I enjoyed it.
What? That's a jump. I mean, I came from Florida to Indiana, mm-hmm. Southern Indiana. So why Denver? What made you go out to Denver?
Well, there were 3 different law schools I was looking at.
Okay.
Notre Dame. There was one in Southern Illinois, and then University of Denver. And it really came down to the best financial aid package.
I see. Yeah. I mean,
it was that simple. But then again, we loved living out in Colorado. Probably the best climate of anywhere I've ever lived.
Tell me about it.
Oh,
it's beautiful out there, right?
Mm-hmm.
And you get all the seasons. You get so much different mix of terrain.
Yep.
You get to really see it all.
And they have over 300 days of sun in Colorado. So
gosh,
that's something to be said for that.
Right? They should call that the Sunshine State.
Mm-hmm.
So you mentioned Millikan University. How far was that from Eureka College? Have you heard of Eureka?
I've heard of Eureka.
Yeah.
Milliken is actually in Decatur.
Okay, so it's in Decatur. So you stayed essentially.
Actually, I went to a community college to start.
Okay.
I did 2 years there.
Yeah.
And then after I finished there, the community college, I transferred over to Milliken.
Yeah.
I did 2 years there, graduated, and then went on to the University of Denver.
Did you play any competitive sports or do anything like that growing up?
No, not really.
No?
I always told everybody I play a great stereo, and that's about it. But, I went to a small Catholic high school.
Right.
So, I was on the basketball team my freshman and sophomore year. But,
Yeah.
I was not competitive.
So you started off your career working at a plaintiff's firm. Tell me a little bit about kind of those early days of your career.
Well, they were early days because it was before there were computers. It was teasing people. I remember when we got our first fax machine. Mm-hmm. And I had one of the senior partners came in, an older guy, and I had to send some documents on a case that was the defendant was in the military, he was serving in Okinawa. Mm-hmm. So I ran the papers through and I turned to the senior partner and said, "They're there." Yeah. And he's like, "What do you mean?" And he couldn't wrap his head around the fact that you could fax papers across the world. And it was funny. But when I started law clerking, we dictated into a little micro recorder, and a secretary had to type it up and give it back to you, and you had to make handwritten corrections and give it back to her. And
wow,
it was really old school.
Yeah. What a difference now. Now every lawyer types, Did you back then, did you dictate because you couldn't type or just because that's just how it was?
We didn't have computers to type on. The secretaries had typewriters.
Right. They were the ones that got the typewriters. That was the high tech back then.
That was it.
That was it.
And when we finally did get computers, they were DOS based.
Oh my gosh.
Oh yeah, it was before Windows.
Oh my gosh. Yeah, I do. I remember that. We had an old one. My stepdad at the time, he was real techie, and so he got a computer when they first came out. But yeah, I remember the old DOS shell program. When I first started, I was a public defender. The city county building downtown used to run this old program called Justice. I don't know if you remember this, but It looked like a DOS shell program. The screen was black and the letters were green. And it was like you were reading The Matrix, like when you were on there on this old archaic program. But that's the government, right? So, a lot of folks, especially trial lawyers, lawyers like you, like plaintiff's attorneys, like me, there's, a lot of times people have a moment, maybe in their life or a series of moments or a certain time where they just realize they're like, I want to be a lawyer. Mm-hmm. So what was that moment for you?
As far back as I can remember, I wanted to be a lawyer, which is strange because there are no lawyers in my family. I was the very first one.
You're the first one.
Very first one. In fact, I was the first one in my family to graduate from college.
Oh, wow.
And then I went and was the first one to graduate from law school. Yeah. And now both my kids are lawyers.
Right. Family full of lawyers.
Yeah.
Yeah.
And my son married a lawyer. So I feel sorry for my wife sometimes.
Oh, my gosh. I wonder what that Thanksgiving is like.
Oh, it's fun. We're all in different areas of practice, which makes it very nice.
That's good.
Yes.
That's good. I always wondered what it would be like. Not so much to practice with your a family member or a child in the same area, but to be on opposing sides.
Yes.
Right? That'd be crazy.
For a while, my daughter was working at Barnes and Thornburg,
mm-hmm.
and I had some cases where they had to notify her, basically put up the Chinese wall to say, look, you can't be involved in anywhere near this case because your dad's on the other side.
Yeah, and we'll talk a little bit later on about kind of some of the areas that you work in, but it's not uncommon for you to deal with a Barnes and Thornburg or a Denton's, right?
No, not at all.
Yeah, or I had him on a case. Kevin Schifferl was on a case.
Oh yeah, Kevin. A lot of cases with him.
Yeah, Kevin. He said he wants to be on the show.
He's a fun guy.
I should bring him down here.
He's a bourbon drinker.
Is he?
I believe he is.
Oh my! All right. Well, then I definitely have to get him on. So, So you start off your career in Colorado, and I know this about you because I've known you for many years. But you're licensed in many states. You worked in many states.
Yes.
Tell me a little bit more about your journey.
Well, I started in Colorado, and we picked up a case that was a product liability case involving a defective portable kerosene heater.
Mm-hmm.
And they were very popular on the market at the time. So I kind of developed a specialty in that, and I began handling those cases all around the country. So I handled them from New Hampshire to New Mexico, from California. So I've handled those all over the country, and that just kind of gave me exposure to all the different states.
Were you pro-hawked in many of those
Yes.
situations?
Yes. Mm-hmm.
Did you always you still do a lot of the product stuff?
I do.
Did you ever, did you always want to do that? Was that, it just, you have to be so technical with that stuff?
I just found that I kind of had a knack for it. I've known guys that actually had passed the patent bar.
Yeah.
And, that's not that unusual to see. Well,
Yeah.
with some guys doing product liability. But, no, I fell into it, and understanding why the product failed was just fascinating.
Really?
Yeah, because like in the portable kerosene heaters, they had the fuel tank was inverted.
Yeah.
And it had a spring loaded, so when you put it down in, there was a needle that stuck up to let the kerosene flow.
Okay.
And it was barometric pressure that held it in place. Well, the problem is if that barometric pressure failed, the tank drains.
Okay.
Yeah. So, and
Wow.
if it was sitting on a rug, you couldn't tell it was leaking.
Yeah.
So the rug would absorb all the kerosene, and all of a sudden, boom, it
The
would
rug
go
would
up.
go up.
Yep. And then, there were other practical flaws in the design. People store their kerosene outdoors where it's cold.
Yeah.
They would fill up the tank with cold kerosene, put it in the heater and turn the heater on, and as the kerosene expanded, it would pressurize and force the fuel out. So there were all kinds of problems with these.
Wow. Was it a primary manufacturer that you had to deal with?
There was one that I dealt with a lot, but even that was frustrating because this company's business model was to rent a factory in the Far East, build all the kerosene heaters, ship them into the U.S., and then close down. So when these things started causing problems,
judgment-proof.
there was no one to find.
Jesus. Similar to, well, maybe not similar, but I know Johnson & Johnson is doing the Texas two-step thing.
Of the bankruptcies.
Yeah, with the bankruptcies.
Yeah.
Yeah. Well, and I mean, you've probably seen that so many times, Tim, haven't you? These companies, they put these horrible products out on the market to make a quick buck, and they're dangerous. They know they're dangerous, or they should have known they were dangerous.
Yes.
And then some bad shit happens.
And sadly, if you're cynical when you approach some of these cases, and it's like, follow the money,
Right.
because it's driving their decisions. And
Right.
I've had way too many cases where you dig deep enough, you'll find those documents, and it's like
Right.
they were aware of the problem, they chose not to either deal with it, or they chose to cut a corner.
Yeah, yeah. Follow the money. I mean, and it's so funny you said that. That's like, you and I have worked on some construction site accident cases, and similar a concept applies there. Follow the money.
Yep, absolutely.
Yeah, yeah. So, going back to you worked in Colorado. What other states are you licensed in?
I am licensed in Texas, Colorado, Illinois, and Indiana.
Okay.
But I've been admitted pro hoc all over the country.
All over.
Yeah.
And you still work pro hoc across the country.
I've got a case going to trial in May in Kansas City. So
Kansas City.
Kansas City.
I brought in, you might know him, Chris Stuckey. He's I brought him in on a case case against an auto manufacturer. He's from Lenexa, Kansas.
Okay.
Lenexa, I think is what it's called. He'd probably kill me if I mispronounced it. But so products cases, we talked a little bit about those. In Indiana, it's tough, right? What are some of the hurdles that plaintiffs have to overcome here in Indiana when you're bringing a products case?
Well, the conservativeness of the juries that tend to be one of the biggest
Really?
problems. I get all the time. I get adjusters telling me, "Come on, you're in Indiana. An Indiana jury's not
God, I
going to
hate
award
that.
that." And we hear it all the time.
Ugh.
Luckily, we've had some good verdicts in this state in the last several years, and
Yeah.
we're not hearing as much of that anymore.
Right.
But it's wild if I get counsel from a major city like Chicago or New York.
Yeah.
They value the cases entirely differently.
That's so funny. What about one of the things that we've had to deal with before is the act, the Products Liability Act. Some of the people watching and or listening on to the podcast, they may not be aware of some of the issues that the Indiana Products Liability Act raises for plaintiffs.
Right.
Yeah.
It's, the codification of Indiana's act is not that dissimilar from other states, or from my experience, because they still use the inherently dangerous. They still use the negligent design, negligent warnings, things like that. So those concepts pretty much remain similar, and the Indiana luckily has some good case law that has developed over the years that if the court cannot hold jurisdiction over the manufacturer, then the retailer can be held to step into the shoes of the manufacturer.
Okay.
And that's come in very handy. I've had some defective fireworks cases.
Defective fireworks?
Defective fireworks cases.
Wow.
And the product was a firework that shot 100 missiles up into the air, and they would go up and explode.
Yeah.
The problem with it, and this is why these cases are so interesting, is it turns out that the missiles fired in a serpentine pattern going back and forth up the rows.
I see, yeah.
And halfway through, suddenly you have no weight on one side and all the weight on the other, and it's vibrating because of the launching. And that's exactly what happened.
It tips over and starts shooting at the people that are watching.
And it went right into my guy's eye and exploded. So,
oh my God.
Yep.
We were at the lake house a couple years ago, and we were shooting mortars in the tube tipped over and shot one right into the garage.
I used to love shooting off fireworks with my kids when they were little. When I got my first fireworks case, it was like,
no more. You'll watch them. You'll watch the professional do it.
I feel bad for them.
My! I should probably do that. I need to take some of your advice. So but that's what lawyers, we never take our own advice, right?
It happens.
So we talked a little bit about products cases, and we've worked on some cases together. But I want to go back to. I want to go back to the first time that I met you. It was probably 10 years ago, over 10 years ago.
Yeah, probably.
And I had, I don't know if you remember this, I had just gotten done doing a presentation on representing undocumented citizens in personal injury cases.
It was an ITLA conference,
It was an ITLA conference. And I did my little 15-minute presentation. And I did that, and then I was walking out, and you came up to me and you mentioned the case that we ultimately worked on.
Yes.
So together. And so, it's funny because to me it was such a big deal and I also work with a lot of Spanish folks, and you do a lot of industrial accident site accident litigation and stuff. So you have a lot of Spanish speaking clients too yourself. So it's a big case if you do work with that community a lot, but some people haven't even heard of it. So yeah, right? Yeah. So tell me a little bit about that case and kind of what happened. And
sure.
And,
in that case, my client was injured on a construction project, and they were moving stones in an outdoor area that had not been plowed. There was no salt down, and 4 guys were carrying this 350-pound piece of cement. They slipped on the ice, and the weight shifted onto my guy, and ended up damaged his back. He was a young man. He was only about 23 at the time, and because of his injury, he could not lift weights anymore, so that pretty much put him out of work in the construction field.
Right.
In the lawsuit we brought, the defense argued that since he was an undocumented immigrant, he was not entitled to recover lost income based on U.S. income because he's not legal to work here. The problem was that he had been working for his entire adult life, had been paying taxes. We were able to provide tax returns. And so we argued that no, his loss of income should be based on what he was capable of making at the time he was injured.
Yeah.
And we had what he was making at the time he was injured as proof. The trial court disagreed with us and basically said that you could only calculate it in what he could make in Mexico,
Right.
which would have been about $4 a day or some ridiculously small amount when he was making probably $60,000 a year here as a construction worker. So it was a significant issue.
Yeah.
So we took it up on appeal. We won it at the Court of Appeals. And I can't remember, were you involved at the Court of Appeals level?
Yeah, no, we lost at the Court of Appeals, remember?
Did we lose the
We
court?
did. It was a 2-3 opinion. It was
Okay.
Judge Bradford, Melissa May, and Judge Baker
Okay.
wrote the dissent,
All right.
which was,
You're
yeah.
right. It was the
Yeah.
dissent that was so helpful to
Yeah,
us. Yes.
the dissent was really helpful.
Right.
It was as long as the main opinion. Like,
Better written, if you
yeah,
ask me.
it was, right. Right. I mean, we're a little biased.
Yeah,
but
just a touch biased. Right.
Yeah.
But then we appealed it to the Supreme Court.
Yep.
And Alex and I both shared the oral argument.
Yeah.
And we got an amazing opinion out of the court. I mean, when I think that's the only case I've ever had where I think they went back all the way to the Magna Carta.
They did.
And it was like, well,
They did.
okay, we're going way back on that.
Oh yeah, they cited the Magna Carta. I mean, it was unreal, and it is a long opinion, but it was very well written by Chief Justice Rush, right?
Yes. Mm-hmm.
Yeah, yeah.
Yep. And I mean, I like the very first sentence where she said, personal injury trials in Indiana should not be about immigration. They
Right.
should be about injuries.
Yeah, and we worked well together on that case, and then since then you and I have worked on other cases together, but it was such and I'll go out on top. I'm 1-0 as an appellate lawyer. You'll never see me out there again. But it was so well orchestrated, the way that we were able to do that, and we got help from Tom Ruge too, from the American Immigration Law Association. They stepped in.
They
the
did
Supreme
amicus?
Court. Yeah. So that was probably, you're a really smart guy. And so you're like a walking law encyclopedia. Like, you know everything. And so I'm more of a practical guy. Like, I like to be in front of people talking to them. And so, but I feel like for you, that is such a great arena for you to do your work in. Whereas me, I am not a big fan of being interrupted by smart people with really even smarter questions.
Yeah.
Yeah. So it throws you off.
I've probably done about 10 appeals.
Yeah, you've done a ton of them.
And in fact, I argued one to the Indiana Supreme Court on October 1st, and we're still waiting for the opinion.
Yeah, that was on my list of questions, so we may as well talk about that one too, because well, let's go back. You've argued in front of Indiana appellate courts, Colorado appellate courts,
And Supreme Court.
And then in Texas, have you done it
No.
too? No. Okay. So in different jurisdictions, different states.
And I've done Seventh Circuit Court of Appeals arguments.
Here. Yep.
Yep. And actually, I had in 1 year, I argued in front of the Indiana Supreme Court, the Indiana Court of Appeals, and the Seventh Circuit.
Yeah. So that's a lot of appellate work. So let's, and I want to ask you about the case you did on Appeals on Wheels, because I thought that was really cool. But before we do that, what to you is the biggest difference between doing appellate work and doing trial work?
Appellate work is a lot more academic, and you have to look at things from a 30,000 foot level.
Yeah.
Whereas in the courtroom, you're thinking short term. What's our goal? What are we hitting here? But when you're doing appellate argument, you have to explain to the court why public policy's on your side, or why, if they decided this way, this is the problems it's going to cause.
Yeah.
So it's a more cerebral approach.
Right. So let's talk about your recent case. Speaking of this case, has a Latin term attached to it that I have not heard since I was in law school. So tell me a little bit about, well, let's talk about what's appeals on wheels. What is that?
Appeals on wheels is when the Court of Appeals, rather than holding their arguments at the State House downtown, will go out to high schools, to colleges, so that people can actually see the Court of Appeals in action.
Yeah.
They get to the people get to sit in on the arguments, and in fact, the one I did on October 1, I think we had 800 people.
Yeah.
In the gymnasium, and I think it's good. The shows the courts are transparent.
Right.
And that our case was particularly good because it dealt with an injured student, and we were arguing in front of a high school of students. So it made it relevant for them. They could see how that would or could impact them.
Right, right. So tell me a little bit about that case. What was that case about?
That case involved a young lady who was a student at IU.
Okay.
They were studying for finals, and there was a group of them. I think there were 4, and they had been sitting in a classroom at a building down in IU Bloomington, had been studying there all day. My client had a pair of headphones on. She had been sitting in her chair for probably 3-4 hours studying, and without any warning, the window behind her fell out of its casing and just hit her from behind.
Wow.
Knocked her silly.
Wow.
And we had pictures. I mean, and it wasn't just the glass; it was the frame. The whole thing just fell right out of the casing.
Oh wow!
And the reason we got into this issue is because my client had no way of knowing what caused the window to fall, and the school, they said, well, we looked at the window and we don't know why it fell either. But there's a rule in the law called res ipsa loquitur. It goes back to about 1840. Mm-hmm. And what that means is that there are certain instances where the facts are such that the thing stands for itself. And that's what res ipsa loquitur means. It stands for itself. And in a situation like that, if you can set it up to satisfy the criteria for res ipsa loquitur, then the court will infer negligence from the happening of an event. And this is a perfect example. Windows should not fall out of buildings with no one touching them.
Right, right.
So that was our issue on the case. And there was a number of cases in the last 40 years that have kind of eroded that and said, well, if you're walking downstairs and you're holding onto the handrail and the handrail pulls out, that's not res ipsa loquitur.
Okay. Negligence, but
right.
Although
that's debatable because I don't know I don't agree with that opinion either. But what happened was there was a case that the Supreme Court decided about 4 or 5 years ago called Menards. I think it was Menards versus Griffin. Mm-hmm. And in that case, a person was at a Menards. They were trying to pull a sink off of a shelf, and the bottom of the box collapsed. The sink fell through and struck the person. The injured person tried to argue res ipsa loquitur, and the Supreme Court said no, it does not apply in that instance.
Okay.
For a couple of reasons. In order to apply res ipsa loquitur, the object or the instrumentality that causes the injury has to be under the exclusive control and management of the defendant. And in that case, they said he was interacting with the box. He was moving the box.
I see.
So it wasn't under the exclusive control.
Okay.
The defense counsel, at the end of that opinion, the very last paragraph of that opinion, the court said, but we want to know or make a point that even though we're not applying res ipsa loquitur in this instance, it can still be applied when it involves fixtures. And a fixture is something that is permanently attached to a building.
A
window frame.
Or window.
HVAC system, those type of things.
Yeah.
Plumbing fixtures.
Right.
So the defense counsel tried to argue that you can't apply res ipsa loquitur to a premises liability case until you satisfy all the elements of negligence, which is a complete a reversal of what res ipsa loquitur is.
Exactly.
So that's why the issue went up on.
And you're still waiting for that opinion?
Yes.
Okay. So, well, we're going to take a little break here, and we're going to come back with part 2 of our Fireside Chat with Tim Devereux.